It is a little past 9, and I know we were supposed to start at 9 o'clock, but we tend to run over because this has all been so very fascinating. And so let me start by saying, for those of you who are in the audience, if you have cell phones, and actually, if you're on the panel or the committee, if you have cell phones, please make sure you put them on silence. The other thing we've discovered is that if you have cell phones and you keep them too close to the microphones, they tend to make it buzz. So if for anyone who has a cell phone, please keep it away from the microphone. We're going to start this morning, and again, I want to welcome our panel. We're going to start this morning with sort of the historical. As you all know, we're looking at the structure of the CJA, and so we're here with a historical perspective on Defender Services, and so I want to welcome all of you here. We'll start with a brief opening statement, and then if you'd leave, especially because we're running a little bit behind, if you'd leave us plenty of time to ask questions, because I think a lot of us have had the opportunity to know you previously, but also because we've gotten your submissions, and so we have an idea of what you want to say in those submissions, and we'd like the opportunity to question you. On our first panel is Mr. Stephen Asen, former Deputy Chief of the DSO, Mr. Robert Burke, former Training Division Chief of the Defender Services Office, and Richard Wolf, former Legal Policy and Training Division Chief of the Defender Services Office. So with that, Mr. Wolf, we'll start with you with an opening.
Sure. I want to thank you for inviting me to provide input for your important study. In 1991, I was hired at the Administrative Office to staff the Criminal Justice Act Review Committee. So I have a sense of the scope of your undertaking and the challenges that you face. Of course, the conditions were quite different. Back then, panel attorneys weren't reachable on the internet. Our best way of directly communicating with them was stuffing correspondence into the envelopes that were transmitting their voucher payments. After the Prado study and report, I worked in what is now the Defender Services Office until March 2014, for the most part as Chief of Legal Policy and Training Division. My joint statement with my colleague Steve Asen focuses on our experience in the AO in terms of how the agency operates vis-a-vis the CJA program, and we will be glad to address questions you may have about it. I want to take the opportunity in the few minutes that I have now to talk about the independence issue with a capital I. That is, the overall placement and governance of the CJA program. In many ways, this hearing brings me full circle in my AO career. I am enormously proud of the work that the Prado Committee did and the improvements in the program that can be traced to it. Things like the nearly universal presence of federal defender organizations in the federal criminal justice system, a network of district panel attorney representatives, and higher hourly panel attorney rates. But what was called the centerpiece of the Prado Committee recommendations, that is the establishment of a freestanding Center for Federal Criminal Defense Services, was not approved by the Judicial Conference. The proposal proved to be highly controversial within the judiciary and among the federal defenders, and so it was cast aside. But the issue has never gone away. Not because of some die-hard advocates who wouldn't let go of it, but because it permeates the very core of the program. For over 20 years, the program has continued to encounter issues far beyond the few that Steve and I referenced because of its placement under the supervision of the judiciary. A court that had previously eliminated its federal public defender organization and continued to require every member of the federal bar, even civil practitioners, to represent CJA defendants facing serious consequences. A circuit chief judge who wanted to limit compensation for panel attorneys to one visit with their clients in jail. Panel attorneys caught between their duty to their clients and their dependence on the court for approval of their compensation and for future appointments. These are some of the consequences of having judicial control over key aspects of the CJA program. Defendants who can afford to retain an attorney don't encounter such problems. CJA defendants shouldn't either. To me, it is a basic matter of principle that the governance of the public defense function should not be vested in the judiciary, which would never consider returning its administrative operations to the Department of Justice as they were before the AO's creation in 1939. Congress explicitly recognized the problem and the ultimate solution when it authorized the use of federal defender organizations in 1970. The Senate report states, "The committee recognizes the desirability of eventual creation of a strong, independent office to administer the federal defender program. It considered as a possibility the immediate establishment of a new independent official, a Defender General of the United States. It also considered establishing a special directorate for defender programs within the Administrative Office of the United States Courts. The committee, however, does not recommend founding an independent office at this initial stage. Such a step would be premature until Congress has had an opportunity to review the operations of the Defender program over the course of a few years. Nor does it recommend placing the overall direction of these programs in the administrative office. Clearly, the defense function must always be adversary in nature as well as high in quality. It would be just as inappropriate to place direction of the defender system in the judicial arm of the United States government as it would be in the prosecutorial arm. Consequently, the committee recommends that the need for a strong, independent administrative leadership be the subject of continuing congressional review until the time is ripe to take this next step." I think the Senate committee had it right back then. I think they understood what was ahead for the program. More recently, the report of the National Association of Criminal Defense Lawyers on the Federal Defender Program emphasized the importance of the CJA program's independence from the judiciary. I fully appreciate that there are counter views. I don't find them persuasive. I also understand the awkwardness of a committee created under the Judicial Conference considering such a position, and the potential futility of convincing the conference. But we are now 45 years past Congress's vision that it be done when the time is ripe to take this final step. In the meantime, the systemic problem will persist. Thank you.
Thank you. Mr. Asen.
Thank you. Well, when I think about the structure of the Defender Services Program, I begin with the recognition that the Criminal Justice Act statutory scheme never really established a national program at all. As you know, the CJA was enacted as a response to the problems that federal judges began to face back in 1938 when in Johnson v. Zerbst, the Supreme Court established a federal constitutional right to counsel in all criminal cases in the federal courts. The problem was that there wasn't any money to pay for those lawyers. Not only wasn't any money to pay for the lawyers, there wasn't any money to reimburse or compensate lawyers for the expenses incurred in putting on a defense, including the use of investigators or any experts that the defense might need for the representation that was required. So, to solve the problem, the Criminal Justice Act authorized local courts to set up a local system for paying private lawyers. It's not a national system for managing these appointments and payments. It was all up to individual judges and local courts, consistent with the federal judiciary circuit council governing scheme, to make arrangements for the appointment of counsel in their districts. Even when federal defender organizations were authorized 6 years later, the decision to have an FDO and the authority to appoint defenders was made at the local level without national coordination or management. Indeed, there's nothing in the Criminal Justice Act that pretends all the systems and oversights that are now in place, all the judicial conference committees that have a say in how defender organizations and how the CJA program is managed, including the Committee on Defender Services, the Judicial Resources Committee, the Budget Committee, the Executive Committee, the Space and Facilities Committee, the Codes and Conduct Committee, or any of the other entities and structures that exist at the national level that so impact the operation of the program today. So for many years, this wasn't really so much of a problem. The program's fiscal requirements were small, and there wasn't any crying need to have a national structure in place or complaints about the lack of a national program being provided for in the statutory scheme. Which is not to say that the people involved in providing services pursuant to the Criminal Justice Act did not care. You tell someone that they are responsible for something, and eventually they think they should do something about it. People want to do a good job, they don't want to do a bad job. And the drive for national leadership came from those who cared about the quality of services being provided and getting the most out of the limited funding that was available to them. That is to say, being cost effective in the context of providing quality services. And these people, for the most part, at that point, were federal defenders, the small group that had been established in the first decade or so after the act. And they started demanding support for the types of services they felt they needed to do a better job. They wanted training, they wanted specialized staff, they wanted investigators, they wanted paralegals, they wanted administrative officers, they wanted to have authorities to travel, to both conduct the business of their offices in addition to doing the investigations necessary for their cases, and they wanted other support. They wanted equipment. They wanted Selectric typewriters, for those of you who are old enough to remember when that was the cutting-edge technology, and then word processors and computers. They wanted all those things in their staff. It wasn't just the leading defenders, it was the people in those offices who were doing the work. It was administrative officers, for example, who said, you know, we need to have a way of keeping track of this money. We want accounting systems. We want to have some ways of managing the administrative responsibilities we have that will increase our ability to do that. Around 1975 or so, the Criminal Justice Act Division in the AO was created to help provide these additional services and provide support for the federal defenders and the program as a whole. Working with the CJA committee, later the Committee on Defender Services, they too began to say, if we're going to do this job, we want to do it well. And the people who staffed that office under the leadership of my former boss, Ted Lids, were passionately committed to the operation of the Sixth Amendment and the operation of the Criminal Justice Act. And committee members, whether or not they, as you heard from a number of former committee members and who testified before you, when they became, many of them had no familiarity with public defense or even criminal defense. But once they became enmeshed in the issues facing federal defenders and the Defender Services Program, they too became committed to improving its performance and to trying to solve the problems that were being encountered. And from these forces, the committee, the staff at the AO, the federal defenders, there emerged, and eventually panel attorneys there, but there emerged the elements of an effective programmatic administration. Defenders and the committee began developing the elements of a cooperative scheme for managing the operations of their offices that produced high quality and cost-effective services. I don't think the same could be said for the panel because the control over the appointment and payment was dispersed among individual judges. And their principal mission was not, nor was most of their time spent on the operation of an effective public defense system. Their independence and lifetime appointments left them unaccountable to anyone for the operation of their panel appointments. And it wasn't really until, honestly, through the leadership of my office and the committee, that we established a national system of panel attorney representatives that we really began to be able to have an impact on the operation of panels throughout the country. My recollection was that was in the 1990s, but who knows. So the judiciary was happy to empower the Defender Services Committee to take on this responsibility until money became a factor. Congressional spending restrictions led to increased focus on all federal appropriations and programs. And as the judiciary's budget grew overall, it began to see a tactical need to limit the growth of the Defender Services appropriation as a way to limit the overall growth in the judiciary's appropriation. And this was pretty much the situation that existed when I started with the program in the late 1980s. Since then, the judiciary's focus and control over the federal defense function, based upon its need to protect its own institutional interests, has steadily increased, culminating in the steps it took in the 2013 year of sequestration and beyond. And I think that the need for national leadership of the federal defense function is now beyond question. It is what Congress requires, even if no one else thought it was necessary. just as there is a need for national leadership of any billion-dollar national program. The CJA may assign responsibility for the appointment and payment of counsel to local authorities, but Congress funds those disparate appointment and payments through a national appropriation, and the appropriation must be managed, which means that the program must be managed in accordance with norms. You have to be able to project requirements as accurately as possible to justify requests for funds, and you have to be able to account for the funds that are expended. And what really may not be obvious to everybody, but you cannot do this without addressing the quality of services provided, any more than a contractor working on your house can justify the amounts charged without reference to the quantity and quality of the labor and materials that will constitute the work performed. At the same time, while there will always be some commonalities among what is required to defend individuals charged with similar crimes in comparable jurisdictions, individuals in criminal cases are unique. And the constitutionally guaranteed right to counsel requires that the persons with ultimate responsibility for determining what time and resources the defense of an individual requires is the attorney assigned to represent that individual. Resolving that tension between adhering to national, regional, and local norms and preserving the autonomous judgment of the individual criminal defense lawyer paid with public funds is at the heart of the task facing those entrusted with oversight of a public defense system. Those who work in the AOUSC and in the DSO in particular are placed in the middle. In the absence of a coherent national program, they must mediate between all the parties to achieve agreement and consensus. Because as noted in our written testimony, the AOUSC has little direct authority. If a judge does not want to follow the CJA's dictates, let alone judicial conference policies, the AO cannot direct the judge to do so. A defender's judgment regarding how best to manage his or her office, let alone how best to represent his or her clients, cannot be second-guessed by the administrative office. And the administrative office must abide by the judicial conference decisions regarding the allocation of funds between federal defender organizations and panel requirements. And even in areas where one might think the AO might have an administrative prerogative, such as the electronic system used to manage the appointment and payment of panel attorneys, and the information such a system collects, the judicial conference decision makers are in control and responsive to the interests of individual courts and judges. Well, the lack of accountability can, of course, be liberating. It allows federal defenders to maximize control over the operation of their offices, and it allows panel attorneys to be, for all intents and purposes, the sole arbiter of the quality of services they provide within the resources available to them. This is not inherently a bad thing. The people who go into this work are, for the most part, motivated to do so, to do the best possible job they can for their clients, which is perhaps the best insurance that the money they are paid to represent assigned clients is well spent. But when the sum of the cost of those individual representations exceeds $1 billion, accountability is required. And we ought to have a program where those who approve vouchers are required to adhere to rules, and those who oversee its funding do not have conflicting obligations. The question facing this committee is not how well the judiciary has done in managing the Defender Services Program within the existing constraints that limit its ability to do so. It is whether there is sufficient, or indeed any rationale, for continuing to operate within those constraints and limitations, rather than making the changes needed to give the Defender Services Program the elements that any modern governmental or business programmatic model would have: a governance structure that has an unconflicted mandate to carry out a clearly defined mission and that can be held accountable for its successes and failures. Thank you. I'd be happy to answer any questions.
Thank you, Mr. Eason. Mr. Burke.
Thank you. Thank you for the opportunity to provide my input. I want to start by saying that,
Can I ask you to get closer to the microphone?
sure, I want to start by saying that it was a privilege in my experience to work in Defender Services and to work with defenders and panel attorneys. There were people who I think were incredibly committed to the Sixth Amendment right to counsel and did fabulous work in providing quality representation to the clients of the program, which isn't to say that I don't think there are problems and that there might be a better way to handle the program. I think for over 50 years, we've been trying to fit the square peg of indigent defense into the round hole of judicial administration. And it is time to create a square hole for the indigent defense function. And one that, as Steve said, is thoughtfully considered and coherently designed so that it respects the independence and quality of representation. The difference in the missions, responsibilities, and interests of the judiciary and defender services, the competition for funding, and the necessary and understandable judicial focus of the AO, as well as its overly hierarchical and bureaucratic nature, make it structurally difficult, if not impossible, to administer the Defender Services Program with proper recognition of and respect for the independence of the defense function and the obligations of the lawyers to their clients. The IT scenario that Steve Kalar presented to this committee, the shift of responsibility for Defender HR, the budget conflicts mentioned in Steve's and Dick's written testimony, and the procurement problems noted in mine are all symptoms, in my view, of the differences in the mission, focus, understanding, and commitment of the judiciary and CJA programs participants and AO supporting those two programs. There are many more examples that we collectively could give you from the time we spent in Defender Services, but I think those are sufficient to highlight the problems. The actions taken during sequestration place, I think, in high relief the problem with judiciary and judicial administrators governing and managing the Defender Services Program. In my view, it's time, consistent with all national standards on the issue, to have the program governed and administered by persons knowledgeable about, experienced in, and unquestionably committed to federal criminal defense and the right to counsel. With regard to panel administration, I believe it's clear from the testimony of panel attorneys to this committee and from countless conversations with panel attorneys around the country at training events and conferences that the judicial administration of the panels is resulting too often in a lesser quality of representation for clients by panel attorneys, not because of the lack of commitment or skills of the panel attorneys, but because of the low pay, voucher reductions, the failure to obtain resources for investigation and experts, and the threat of removal from the panel for vigorous representation of the clients or advocacy for themselves. I want to say that I feel also privileged to have worked with the Defender Services Committee. I think as a body, that committee has advocated vigorously for the independence and quality of representation of the program. Some members came with defense experience and understandably, had a grasp of what the program and the obligations of the lawyers were. Others came, I think, with very open minds, listened, learned, and understood what the issues were. But I think even the makeup of the committee presents sort of a schizophrenic view of the program within the judiciary and the AO. On the one hand, the program is considered part of the judiciary for administrative purposes and processes. On the other, not so much for governance. And that's reflected, I think, by the fact that there are no voting members who are criminal defense attorneys on the Defender Services Committee. I made some small number of recommendations in my written submission. Since looking at that and thinking about it some more, I have some additional ones, and I'd like to close by identifying what those are. I think the Defender Services Office should not be a part of the judiciary and the AO at all, but a separate independent entity. If the Defender Services Program remains within the judiciary and the AO, the structure should be changed to give it greater independence, including direct access of its chief to the director of the AO, DSO having direct access to Congress, and institutionalization of the use of federal defender legislative detailees in both chambers of Congress. A majority of the Defender Services Committee being made up of federal defenders and CJA panel attorneys. The Defender Services Committee having responsibility for the program budget, including human resources, and the restoration of the IT function to Defender Services. Also, if DSO remains within the AO, I believe the training division should not remain there. It provides substantive, not administrative support to defenders and CJA panel attorneys and should be moved back into a federal defender office as other substantive support projects are. In fact, consideration should be given to an amendment to the CJA that would allow for the creation of a defender and panel attorney support office to address training and specialized areas of practice. Judges should have no involvement whatsoever in the administration of the CJA panel. That function should be performed, as all national standards require, by persons knowledgeable about and experienced in federal criminal defense and independent of the judiciary. More funding should be provided for training, including more funding to pay the travel costs for panel attorneys to attend training, and the creation and funding of training positions within FDOs. That is, staff that work on at least a 50% reduced caseload and also have responsibility with the assistance of the training division for local training. Additional funding should be provided to Defender Services to manage, particularly with regard to panel attorneys, the increasing volume and complexity of electronic discovery. Consideration should be given to establishing, at least in some districts, special panels of attorney with specialized training to be appointed in cases involving voluminous or complex discovery. Any amendments to the CJA necessary to implement these recommendations should be pursued. Thank you.
Thank you, Mr. Burke. All right, we're going to go ahead and start with the panel. And let's start, Mr. Frensley, do you mind starting?
Sure. That'll be fine. Thank you all for being here. It's good to see you again. So I wanted to start with Steve. One of the things that's always struck me about about Defender Services within the administrative office is what I perceive to be the tension that you and Dick allude to in your written submissions, and I kind of see it as the serving of two masters, and the idea that you have judges who are contacting Defender Services and asking for information and wanting you to do things, and then at the same time you have defender organizations and panel attorneys who have their own needs, and when those two needs conflict, what does Defender Services do? Can you talk a little bit maybe about that tension, and perhaps to the extent that you are familiar with maybe some specific examples where you felt like that tension really came to bear itself, and how you feel like that the office could do better in those situations?
Well, I think that I agree with you about that tension. We have to understand that, we took the job, we knew that we were working for the Administrative Office of the U.S. Courts, and we knew that the mission of that is to serve the federal judiciary. And I guess the conception is that what the federal judiciary wants us to do, because we were assigned to the Office of Defender Services, is to do what we could to support the judiciary in having the best public defense system possible, highest quality, most cost effective, and that's the primary interest. So we felt that. So what I would tell staff and what I would tell judges when describing what my mission was I'm here to tell you how to go about, help you, give you advice on how to go about doing that. And the problem is that when judges would call us up for advice, or other elements within the AO or the judiciary would call us up for advice about the program, their interest was not necessarily in having the best public defense system possible. Their interest might have been, I want to have control over the lawyers who appear in my courtroom. It might have been, I want to ensure that I can decide who I appoint. It can be, I want to make sure that the budgets are kept under control and don't impact other parts of the appropriation. So when that occurs, there's a direct conflict. And there's a conflict that arises. And the hope is that the people that in carrying out your message, saying, well, you may indeed want to have control over the lawyers in your courtroom, the hope would be that you could say, well, I know that you do, Judge, but what we have to focus on is making sure that we have the best lawyers there for this client, maybe not just the best lawyers, but also the ones that can provide the services most cost effectively. And when and I would hope that the people above me in the agency would support me in doing that. Well, that really doesn't occur. Okay, so that's would be a nice hope, but that's not really what the reality is. The reality is that, as we said in our testimony, the mantra in the AO is you are there to serve the judges and do what they want as a result, not necessarily what you think is programmatically the best thing or anything else. If this is what the judge wants to do, talk to them and provide advice, but in the end, you want to do what they want to say. So there was a conflict, and how we resolved that I guess I'm not able to really go into. It's just a multivariate ways. That was a day-to-day business that you had to do there. So you do that by bringing other judges to bear to try to persuade, or to try to bring other people involved to try to communicate with the courts, or those people who wanted those different results. But oftentimes, it would become a very complex situation. And I think that one of the most difficult examples that became very problematic for us had to do with the provision of counsel in death penalty habeas cases. I've always felt, in my experience working in the program for all these years, was that the death penalty representation puts into high relief problems that exist throughout the entire system, but you don't always see them. But when they come into the death penalty area, they do come into high relief. So, as you know, that one of the things that was accomplished during our tenure was the creation of specialized units within federal defender offices to provide representation in capital habeas cases. So not every district that had capital habeas caseloads had capital habeas units, and that's a whole another story which we could talk about why that is the case. But situation arose, for example, in Texas, where we had there was a need to have, I guess this was alluded to, I think, in Steve Wright's testimony, where a judge wanted to have needed a lawyer to provide representation in a capital habeas case, and sought the assistance of one of the resources that the committee had established to help in that process. One of our death penalty resource councils, a recommendation was made to them, and we were able to arrange to have lawyers from our capital habeas unit in California Central from LA come and provide representation in that case. And when the chief judge of the circuit found out about that, she was offended and called up and said, "What are you doing? I don't want this to happen. I think we can do it more, I want to have Texas lawyers providing this representation." And the result of that was getting the committee involved and getting our chair involved, and a lot of discussions. And out of that became an elaborate protocol agreement, which I think the committee may have been familiar with already, for providing for the representation of people in one district by lawyers in another, coming from another district. Now, so the resolution of that was, my understanding was that, during my experience there, it became a very complicated process for affecting the provision of counsel in what I think should have been a fairly simple, straightforward manner. And we do it. I think that I don't recall during my tenure instances where we weren't able ultimately to get the lawyer that we wanted that the district judge really wanted into the courtroom. But it became very time-consuming and complicated. And that's the type of thing that would happen. We would look for very sort of elaborate, more and more solutions, and involve more and more parties in trying to get a solution. And when you do that, the solution could become very complicated.
Dick, Bob mentioned some very specific recommendations that I perceived as ways to improve independence but maintain a presence within the judiciary. And I was wondering if obviously it's something you've given a lot of thought to. Do you feel like that there are any sort of outer limits to the amount of independence that could be achieved in the defense function, but still remaining within the ambit of the judiciary?
Are there outer limits to it?
Right. In other words, just things that you just can't get to in terms of independence as long as you stay under the judiciary.
I think what comes to mind to me is the feeling that this is a separate function. It's the adversary function in our system. And defense attorneys have expertise in that function. The judges have expertise in, adjudicating, but many of them haven't been defense attorneys. And I will echo what Bob said, actually, that the Defender Services Committee, I think, has done an outstanding job. People did come to it with varying degrees of experience and have been great advocates for the program. But even with that, help and assist from that committee, there are limits to what is able to be done. And not only are there limits, but at times the Defender Services Committee just isn't listened to. And, I know you've heard a lot about the jurisdictional change, for example, that the Executive Committee imposed in moving jurisdiction away from the Defender Services Committee. So there's an internal judiciary power structure, if you will, and defenders aren't a part of it. And so I don't think they can ever really hope to have administration of this program in the way it should be without them having the leadership role. I think in some ways when Prado won, and back in the early 90s, the system maybe was too immature. There weren't, defenders in many places. And I also think, as using Bob's square hole analogies maybe, that when resources are big enough, when the hole's big enough, the square peg can fit in there. But it was only when resources started getting squeezed, and sequestration being an example, that the friction and really came to bear. And that's when you saw, I think, the defenders stand up and say, enough. I mean, they got, an incredibly rare anomaly from the Hill to the sequester. And they have likewise, I think, with the jurisdictional change, stood up and been more than active participants in this work measurement formula that was imposed upon them, taken away from Defender Services and given to another committee. And so that's what convinces me more and more that they don't need what they probably did need in the beginning of this program was the assist to sort of be nurtured and to grow into as good a program as it is by the judiciary with its protection. But I'm very convinced the federal defenders can stand on their own. And I think for the panel, it's even an easier job in the sense that you're not literally under the wing, but you have all the pressures of having your compensation and appointments and all the rest judiciary led. In answer to also what you were asking Steve, it makes me think about the voucher reduction guideline, which we almost take for granted now. But back a number of years, voucher cutting was a major complaint. And at that time, the guidelines, the Judicial Conference policy was that a judge, I think the language was, may wish to inform counsel when there's going to be a reduction. And we took it to the Defender Services Committee, our supportive committee, to recommend a change to that guideline. And we were very disappointed, to put it mildly, that they at first did not support that change. And it got heated, quite frankly, about it. And it took some more time before we got what is now the guideline. And I think Judge Gleason's, as chair, basically almost shamed the judiciary into saying, this is a fairness issue. We're about fairness. That's, it shouldn't come to that. And I think what's so frustrating from our vantage point at times is how much effort is required to get some very small, what seem like some very small and reasonable steps. It's still a guideline. Any judge who wants to cut a voucher, and not contact attorneys can do that. But I actually do think the culture gradually has changed on that to the better, and I'm pleased by that.
And I just want to add to what Dick's last comment about how frustrating it is. It's not just frustrating, it's incredibly wasteful and inefficient. In the 17 years I was there and the 20-something years I was there, I can't tell you how many meetings we had to go to. Countless meetings, hundreds, maybe thousands of hours of work explaining the responsibilities and the interests and the mission of our program so that people who didn't understand it could understand why it had to be treated differently, rather than having administrators who are aware of what those issues are, understand them, and can make the decisions in a much more efficient way and in a more economical way.
And I just want to offer, by way of example, just to give you the types of things that I thought were daily occurrences. So I remember during those discussions with the committee about the Statement of Reasons guideline, and it was going back and forth with members of the committee, and we had a very...
You're talking about Defender Services?
Defender Services Committee, made up of very good people who really cared about the issue, and one of the judges who was long history of being very active in his local, his courts, administration of their CJ panel, and was all in favor of this guideline. And he didn't really understand what the problem was, because when he would take those CJ vouchers home on weekends to review them and give them a thorough review, because he felt that's what they deserved, as indeed they did, he would write extensive comments on any cuts that he made right on the voucher so that the panel attorney would have the advantage of knowing that, and he didn't think there was a problem with that. Of course, he'd been doing this for a number of years, but what he didn't realize was that the panel attorneys never got those vouchers back. The vouchers were never returned to the panel attorneys. And here was a judge who cared about the program, cared about the issue, thought he was making a difference, but because really, this wasn't his job. He didn't understand how the actual mechanics of the program worked, and no one was reviewing what he did. No one said, okay, you're the person who's reviewing the vouchers, you want to put a statement of reasons, this is how you go about doing it. No one did that. So it's an example, I think, of how even very well-intentioned judges who care about the program can try to do their best, but because it's not a professionally run program, it doesn't have standards and requirements, it doesn't have a system of professional voucher reviewers who are trained and then audited and then their work is reviewed and all that sort of stuff. You can have people who make very good, well-intentioned efforts to no avail.
Dick, one of the concerns that's often referenced, particularly in light of the budgetary issues and sequestration, was the fact that many in the judiciary perceived resources to Defender Services to diminish resources available to the judiciary. And I'm just curious how you would respond to the concern, perhaps, that if the defense were independent from the judiciary, whether and to what extent that same concern might exist as between the panel and resources to defender offices, and if that conflict would be exacerbated by the independence itself.
So we're positing that the program is independent, and then your question is panel versus defender
Right.
allocation.
Right.
Well, I think that goes to what the governance structure would be, and I would think that you would want to have a representation of both, defender and panel interests in a fashion that you have to come to some understanding of what that's going to be. I just think that's the give and take of governing a program, and you have to listen to your constituents and make that decision.
And I assume you think that tension would be preferable to the tension that exists between the court and the defender function.
Absolutely. I mean, I think one of the most difficult things under the current system is just, now the Defender Service, I know you've heard this before to some extent, but a budget request comes out of the Defender Services Committee, and then it goes to the Budget Committee, and then it goes to the Judicial Conference, and the ability to shape and fashion that after it's left Defender Services is very difficult. And I don't want to make it sound like there's always great conflict and upheaval. I think in many instances, the judiciary and the committees might align on how the breakdown. When we were facing shortfalls, I mean spending plans, for example, the strategy that was followed, and I think with as much success as you could hope for, was fund the defender offices, keep those operations going, and if you have to, you suspend panel attorney payments. And that sometimes led to a supplemental appropriation from Congress, recognizing they had to do it, or the next fiscal year when funds became available, that shortfall was covered. And so I think that was a successful strategy in tight times, and the judiciary followed that up until the sequester, and that was a time when there wasn't alignment. The panel attorney rate cut, I think, was something that came as a total shock to the system, if you will, because we've been working for so many years to get the rate increase that anything signaling a cut in that rate seemed so counterproductive. And that money was lost. I mean, that wasn't money that was, paid back when funds became available. Those dollars were gone. So panel attorneys who are already operating at the, rates that are, as fashioned pro bono, below market rates, and are not the statutory maximum, were reduced even further.
Thank you.
Chip, can I just, I'm here, I'm sorry. Just want to offer up that I think that one of the things that really distinguishes those situations that you posited to Dick is that, is what the mission and the mandate is of the decision makers. So it's interesting to me that the strategy that Dick described is one that both you and Ruben participated in developing as members of the Defender Services Advisory Groups, that it was where we had a common goal, that we had a common mission, an agreed upon mission, that we were going to try to preserve the best public defense system we could. And so there's a debate about how do you go about doing that. And there's a reason that the decision about maintaining federal defender staffing levels and funding to do that at the expense of suspending panel attorney payments, there's a reason why that decision was made, and it was agreed upon by by both panel attorneys and defenders. And it could have been different. There could have been a different balance. It could have said, well, no, I don't want to just maintain defender office staffing levels. I want to maximize them because, that would give us maybe longer term, maximizing defender organization representations, which was one of the program's goals. But it was a compromise. It was a decision that was based upon reason and judgment. That's different than if you were to sit there and say, well, let's have the person who's running the Department of Justice be the decision maker on how we're going to balance that decision, or if it's going to be the Judicial Conference making that decision about how to do the balancing. So I think that what distinguishes it and what allows you to resolve those conflicts is having the common mission and goals.
Can I follow up on that? Because one of the criticisms we've heard is that decisions were made to sort of always defer attorney payments, and for those who weren't part of the committee or understanding why those decisions were made, it was seen as a way of sort of putting off money and making a debt that was going to have to be paid for the next year. And then merging that with sequestration, there was a concern that the executive committee felt that it was just not being managed well. Do you have any input about, in other words, you were just sort of avoiding, or that, or Defender Services, the Defender Services Committee was sort of avoiding the idea that sequestration was coming and that Defender Services just didn't think that should happen to them. Any comments?
Well, I mean, I have, yes, I'd like to comment upon that. I think that I guess there's a couple of different things to say about that. In the first instance, you have to understand that when sequestration happened, no one thought sequestration was going to happen. The President of the United States didn't think it was going to happen. Leaders in Congress didn't think it was going to happen. No one thought sequestration was going to happen until sequestration happened. And the judiciary had a longer-term concern, which we've discussed and you've heard about, we all know about, of controlling costs in the judiciary. So they had a multi-year interest in reducing overall judiciary costs, including reducing, as we've discussed, for the reasons we've discussed, and reducing Defender Services costs. That was coming from the Judicial Conference, and they had their reasons for doing it, which I think had to do with limiting the overall growth, as we've discussed, in the judiciary's appropriations. But Congress had not taken that attitude towards Defender Services. Congress was not saying, oh, Defender Services, you're out of control, your spending is way out of control. They had been, they were funding us based upon assumptions that the Defender organizations were efficiently managed. They wanted us, of course, to have more efficiency, but no one was saying we were out of control in that area. And they were prepared, as they eventually, and they believed that the panel attorneys were a necessary payment, that they didn't think that, you know, there was all these different judges approving the individual payments. The idea that there was, that they were somehow being, and the average cost per case was relatively low, especially compared to private bar metrics, and it had not been rising in any particularly significant measure. So they saw our program largely as a mandatory program. Even though we're not a mandatory program, we don't an entitlement program. The language of the statute is largely written in language similar to entitlement programs. It says that if you get arrested and you get charged with a crime, you're entitled to a lawyer. If it had said you're entitled to receive money to hire a lawyer, it would have been an entitlement program, but it didn't. It said you're entitled to have a lawyer appointed. So the fact that the payments have to come from someplace else takes out of that entitlement category. But the Congress funded us based upon that assumption, and that's why year after year we would get the additional funding. They did not, their view about us, when we would have those, it had happened in a number of years, in a number of different fiscal years prior to sequestration, that there was a shortfall. And Congress, yes, we did run short, and Congress did have to fund us out of the next year's funding, but it wasn't, and would they prefer not to have to do that? Yes, they would prefer not to have to do that, but they continued to provide us with the funding that we need to meet those payments because they thought it was reasonable. What the Judicial Conference, though, they had a different viewpoint. They thought that our program was not taking the same types of cuts that the rest of the judiciary was taking, because they weren't getting funded in that way. And in order, they felt that why should our program, why should federal defenders be able to continue to hire staff to meet increasing caseload demands when our clerk's offices can't do that? So they wanted us to join in this larger effort. It wasn't because Congress wanted us to do that. It wasn't because there was some mandate that was threatening the future of our Defender Services program because we weren't taking enough cuts. It was because we weren't on board with that. So yes, their complaint was that we weren't like taking radical cuts in anticipation that sequestration might happen. We took the view that, as Congress had taken, that this is a constitutional mandate and that you can have all the sequestration you want, but when you're going to arrest somebody and charge them with a crime, they're entitled to a lawyer, not a sequestered lawyer, they're entitled to services. And the view that we put forward to Congress, which I say we put forward to it, was the basis upon which we based every appropriation request. We were asking for the amount of money that was needed to provide the basic elements of a defense, not a Cadillac defense, not a Ford defense, a Sixth Amendment defense. There wasn't a lot of excess money in there to pay for those that we could like frill away. If you don't give us the money, our representations were going to go down. And the Judicial Conference, the Executive Committee, in developing a spending plan, they believed, no, we can cut defender organization funding, and they can, and it will not increase the number of panel attorney appointments that we need to increase panel costs, because they can provide representation, represent the same number of people with less money. And that's the position that they were going to take, which I think was a position which Congress, which did not assume was true. And I think, in fact, was not true. It's not to say that you can't, get by with less for a little bit more, but but operate as a basic assumption that you're overfunding the program for the amount of work that's necessary, I think was simply incorrect. And it wasn't just in the sequestration year. If you looked back to the records from, I think, like 2012, 2011, I can't remember the specific dates, but there were decisions made and recommending appropriation requests in the Budget Committee's approval of Defender Services, recommendations regarding Defender Services appropriations requests, where they would come in and they would look at our request that was put forward by the Committee on Defender Services, they'd look at the justification for it, and they would say, that's simply too much. We're going to cut that appropriation request by X percentage.
It's simply too much because?
Because your percentage, because it is too much, it's too much of a percentage increase over the previous year's funding level. And it will jack up our overall judiciary appropriation request to beyond the percentage that we're trying to limit it to.
And therefore?
And therefore, we're going to just arbitrarily cut that in response to.
No, but and therefore, what would be the consequence of the request exceeding that predetermined amount?
They believed that it would undermine their advocacy for the entire judiciary's appropriation before the Congress. It would make it less successful. And what was really, that particular year, I thought was really striking about that was that it was there, and other times when they had, in previous years when they had, we would go to the Budget Committee and we'd have this debate about whether or not our request was too high or too low, or it was too low, but whether or not it was too high. There would be a different analysis presented to us from the budget staff at the AO that would, supporting the work of the Budget Committee, would say, no, your request, you miscalculated. You don't really need as much as you say you would need. You need less. And we could get in some debate about that. And then that's how where the fight would occur. But this was an instance where the Budget Committee said, we're not going to debate your numbers. We're not doubting what you're saying, that is the calculation of what is needed. We're just telling you you're not going to get it, and you're going to have to operate with less. Now, it's one thing if you're a local public defense system or you're a national public defense system, and your funding source says that to you. You have some hard decisions to make. And how you deal with things when you actually have a sequester, when you actually get a cut, is something that we could spend a lot of time talking about. But it's quite another thing when the agency that is responsible for your program is prepared to go forward to the funding source and say, you know what, you can just, we're not going to go forward and ask for all the money that we think that we actually need to manage the program. Now, it may be that I don't know what motivates all the judges on the Budget Committee. It may be that they actually believed that even though they couldn't put their finger on it, they couldn't do an analysis of it, that there just had to be a way for us to provide the same level of representation with less money. I don't know. Wasn't transparent at all what their actual thinking was. But as an administrator in the program, someone who works for the government, I felt that our responsibility is to make decisions that are transparent, that are based upon reasoned analysis, not based upon supposition, whim, some thought that you have based upon whatever experience you had. It should be subject to a process. And the process that we were subject to had none of those elements of transparency, stated rationales, and reason. And I
So-
think,
And I think this is an important example for demonstrating the tension and the difference between having governance and administration by people who are knowledgeable in the field. Because all along, the defenders were saying, and the people in defender services who are knowledgeable about it, this is what our needs are. And there were many in the judiciary among the budget committee who said, no, you don't, and in the AO who said, no, you don't need that much. And when sequestration came, and when the work study came, after not having given credence to defender services and the defenders about what their needs were, it turned out the defenders were right. They had
Sorry.
pretty accurately identified their needs in terms of human resources and other capital.
Just a quick follow-up, Ms. Drayson. So what was going to be the plan one of the criticisms is that you weren't planning for sequestration. So if this budget that you had put together and sequestration happened, what was the plan that by deferring payments to the attorneys, you felt that Congress, because they knew it was pretty much a mandated, you had to give people defense, that they would realize, they would figure out where to get the money to pay them the next year? Was that the idea, rather than to do some sort of cut the way it was done?
well, let say this, that there was a plan. I don't, there are better sources for what the plan is than what I'm going to state here, but my recollection is that the committee, working with the defenders and the advisory group, had come up with a proposal that involved certain amount of funding going to defenders, I believe, to keep on board staff, and or pretty close to that, I think. And then there would be some cut to the panel attorney portion that would require suspension of payments. And depending upon how the numbers worked out, I think there was provision for furloughs at some point later on in the year. So it would have been a less dramatic cut. And one of the things that, one of the advantages that was true about this approach that the committee and the conference had taken prior to the sequestration year of the suspension of panel payments is that a lot of things happen during the course of a fiscal year. If you make a decision, so that oftentimes we would be projecting, for example, a suspension of panel payments will be like 6 weeks this year. We're going to have to start suspending panel payments the middle of August. And then by June, it comes around, well, the defender expenditures weren't quite as high as we projected. Panel cost payments weren't being expended at quite the same rate.
They
Now it
weren't
looks like
indicting as many people.
Right. Now it looks like it's a 4-week suspension. And then it comes to like 2 weeks before, and we found some money, and we can transfer this money from some other account and make up the difference, and it's only a 2-week suspension. And you have those sort of options to play with, as well as the options that, who knew what was going to happen during sequestration? It wasn't, hindsight's a great thing, but it had never occurred before. And yes, there was clearly a possibility that that the Congress would respond and say, well, we're not going to, let the payments just sit there for 6 or 8 weeks, or that if that happened in the following year, we would have, that the impact of that would have been such that we would have achieved protection. So those are some of the things that might have happened. But the other thing about it, to understand, is that thinking about what would happen is different if you're, depending upon what your overarching advocacy strategy is on the Hill. And what would happen might be really different if you had, if there was an independent agency with this sort of solely focused mandate that was focused on how best to ensure the funding for this program during this period of sequestration. You would make a different calculations, you'd have different risk factors, you'd have different opportunities for success than you would if your battle is being fought within the judicial conference for how they're going to manage their overarching federal judiciary funding strategy to get through sequestration. How are you going to present your overall picture when they weren't suffering the same number of potential cuts that federal defender organizations were facing. So they had a whole different strategic approach. So it may be that, I hope, that if there was the chair of if Judge Gibbons were here, or the then chair of the Budget Committee were here, she would be able to articulate a really good rationale why this made a lot of sense for the federal judiciary as a whole to take this approach. So that may have made sense for them as a whole, but within that context, this program gets hurt. Now, a lot of things have to be balanced. The issue is whether or not it is acceptable in our constitutional framework to have the judiciary's interests balanced against the public defense interests. If it had been a question of the judiciary balancing off probation officers' offices versus clerks' offices versus circuit executives' offices, you have to make judgments, you have to make balances. And that would seem to be entirely appropriate. I think the question here is whether or not it's appropriate for the judiciary to be making these balances where they have, where they're doing it between this sort of separate, independent defense function, which really has an oppositional interest within our, adversary system.
So let me try and drill down a little on this, because I heard Mr. Burke say that he thought there was a failure of knowledge, that the Budget Committee didn't properly appreciate that when defenders said, these cuts will do X to us, they really would do it. And you're positing a sort of different mechanism, which is that the judiciary had to balance its overall interests against those of the defender program in the circumstances, and the interests conflicted. And so I guess I'd like to turn to Mr. Wolf and get his view on how he sees what occurred in sequestration. Was there a failure of knowledge? Was there a failure of planning? Was there a conflict in interest? What drove the problem?
Ultimately, I wish I knew. I wish I could answer that I know for a fact what drove the problem. I think that we had a sense that that what the Defender Services Committee was saying, and which is the committee most knowledgeable about it, was not being heard or listened to. And that was particularly concerning. I think there were people, and they, they may have been well-intentioned. I can't know that for sure. I think part of the problem is, there's always the anxiety, quite frankly, in our position of not knowing whether this is just a misunderstanding or lack of knowledge, or whether there's a deliberate attempt to limit resources. And I have to say, there are times, sequestration was one of those things where it seemed like there was a real attempt to limit the resources, and I think that happened at other times too.
Well, let me ask about that. My recollection is that prior to sequestration, there had been a decision by the Budget Committee, I guess endorsed by the Judicial Conference as a whole, to impose caps on the growth of the Defender Services account that weren't directly related in any way to the judgments about the needs of the program or the growth in caseload or anything like that. They were essentially fixed caps of a certain percentage level. Is that recollection correct?
That is, there was a time in which I think the Budget Committee viewed, well, the appropriations climate is tightening. We've got to try to limit our increases. Our subcommittee only gets so much of an allocation, so we have to try to limit what the requests are. And there was a decision, the Budget Committee that was endorsed that the different appropriations have a cap on them. The cap, our program, and we've heard about the dollar for this is not, a dollar for CJ is not a dollar for the courts. Our program was growing at a rate faster than the court budget was growing. And as I recall, the way the budget caps ended up coming out reversed that. That is, the cap would allow us to go up, let's say 5%. The courts were a little more. So it sort of altered the balance.
So let me ask you explicitly, did any of you hear that view expressed within the administrative office that $1 for the Defender program was $1 that salaries and expenses account couldn't get?
I mean, I attended meetings in which that was said, the Budget Committee chair said that, you know, to other chairs of committees, and, you know, that was not any secret.
Okay, and
that
that was a
sense.
reason to restrain the growth of the Defender program?
I mean, I think that they looked to the Defender program, you know, the chair of the Defender Services Committee was also often in a very uncomfortable spot in those meetings, because they were being looked to, you know, restrain the program growth, and what are you doing? And, you know, there were a lot of different things. There are different ways of containing costs. And I think we had some strategies for containing costs, and the Budget Committee had some strategies. And it was very difficult to promote ours and to fend off, if you will, theirs. And some of the things I think about are you know, for years, benchmarks were talked about for panel attorney payments. They wanted benchmarks. And I think part of it was just to help judges. This just goes to judges having to make decisions on vouchers and trying to figure out how to do it. And the hope was that by having data with benchmarks on a certain type of case, it will cost this much, that would help the judge. We told them our payment system won't give you data, you know, it's sort of garbage in, garbage out. We couldn't tell if that this case was a plea or a trial, it was a single defendant, multi-defendant, but there was insistence that this be done. And eventually benchmarks, these were issued with so many disclaimers on it. I mean, we insisted that there be these disclaimers that they were really useless. And yet we thought, for example, on the other side, one of our suggestions was supervising attorneys in the courts could be helpful for judges. And the first time that we took that on, because it was in the courts, the supervising attorneys were in the salary, taking out the salaries and expenses account. And so it was piloted, I think, and there were 3 of them. And after the pilot, the decision was, the Judicial Resources Committee, I think it was, basically took the view, or court administration and case management, I can't remember. But the point was, this is going to come out of clerks' formulas. So the answer to that is, there will be no additive for this. You cannot add to your clerk's formula to have a supervising attorney, which in the end, I mean, I think the 3 were grandfathered in, but it basically stifled that. So then the next go-round was case budgeting attorneys. We you know, came to the conclusion these large cases, large panel attorney cases, often death penalty cases, were costing such a large percentage of the panel attorney portion of the program compared to the number of representations. But the case budgeting was a process by which, instead of waiting for the end of the case and the judge getting sticker shock, you know, that it had added up this much, to do a case budget early in the case, and which could be altered. So there was a common understanding of what sorts of expenses could be expected. And case budgeting attorneys were piloted, and they're experienced criminal defense lawyers who could help do that. And this time, we decided we'll take this out of Defender Services money, and we will have an FJC study done of it, because we're always told there's not empirical data supporting these things. And that pilot was done, and the FJC study came out and said that those case budgeting attorneys had more than covered their costs, and that this was a good program. And ultimately went to the Judicial Conference then, and the conference endorsed those positions. And I'm very gratified to hear that, I didn't know that there are like something like 10 out of the 12 circuits now. But even after that conference approval, we got, one of the members of our economy subcommittee, our liaison, was complaining about the FJC study and how it wasn't, you know, the faults in it and everything, you know, because this was a, you know, this was going to be, at that point, 3 people, but potentially 12 FTEs, you know, added to our appropriation. Even though the study was showing it was saving money, even though the panel attorneys liked it ever so much, you think they wouldn't have liked it? They were endorsing it. It was, everybody was on the same page. And judges were endorsing it. But we were getting pushback even after conference policy was that this was a worthwhile thing to do from our appropriation. We were getting pushback about that.
Any other questions?
Let me give Dr. Rucker some time.
All right, go ahead, Dr.
Otherwise, I
Rucker.
could eat up the rest of the session.
I think we all could. So it's nice to see all of you. Thank you for coming here. If I've understood what some of you are saying, and I think all 3 of you actually, you're calling for independence. So let me ask you to talk a little bit about that. What form would you like to see this independence be? Would it still stay within the judiciary in some form, like an FJC model, a sentencing commission model? Would it be outside? And tell us how this would work. How can we better support the 6th Amendment and people's right to defense? And how do we get to this model that you're envisioning in a real world, not an idealistic world, but realistically? Mr. Asen, you want to start?
Oh, yeah. Well, you know, I think that for, certainly for me, when I entered government, you know, it's a mystery. How do you actually run programs and do all this funding, and how does it actually all work? It seems mysterious in that, and complicated and complex. How would you go about doing this? I think that there are really I look at it, at the reform for the program as existing in 2 spheres. One is at the national level, setting policy, doing the appropriation, doing the budgets, and the other is in the area of the appointment and payment of counsel, both at the, you know, the panel attorneys and the powers of the district courts to do that. So you have to address both those problems. And I think at the national level, I mean, to sort of get to this question, is there any limits as to what you could, Mr. Frensley asked, is there any limits to what the autonomy can be within the judiciary? I don't really think that there are. We have to think about what it means to be within the judiciary. If you consider the Sentencing Commission to be within the judiciary, the Federal Judicial Center to be within the judiciary, I think you can have one of those models. The first, you have to do really one very simple thing. You have to remove the authority of the Judicial Conference of the United States over the program. So once you do that, you have to vest it in something else. And once you do that, everything else can sort of basically remain in place. And that authority that has now replaced the authority of the Judicial Conference then becomes responsible for figuring out all the details of what other operational adjustments you might need to make over time. So what would that look like? Well, you have models from state systems, right? But you have models within the federal judiciary. You have, you know, you could do the Sentencing Commission model. You could have a board. You could make that. You could look at the functions of the Committee on Defender Services now. Say, those functions are now going to be vested in an independent commission, and you could initially keep the Committee on Defender Services the way it is and let it figure out a system for replacing it, or you could come up with, I'm sure you've been looking at different models, well, how you might constitute that.
Could I, I'm
yeah.
sorry to interrupt you, but when you talk about that, the way the Defender Services Committee is right now, it's basically judges running it.
Right, but I'm saying that it is running it, but you look at what its authorities are. You take the authorities that it has and you say, that's going to be our independent commission. And the role that it plays, and staff in the AO, the Defender Services Office, they no longer report to the director of the Administrative Office of U.S. Courts. They can keep their offices there, and you can reimburse the AO however you want to do it. And they do this, the functions that they're performing, but they're simply now reporting to this and responsible to this commission, the same way that administrators in state systems that report to independent commissions are responsible to them. And the functions that you have within the AO that support the program, personnel, these different administrative functions, they can still be there. You can contract them with them on a reimbursable basis, however you want to do it. But that's really, if you look, there are other models to look at. You can look at the Office of Independent Counsel, that if you all recall what those used to look like. I'm familiar with it a little bit because my wife used to be an associate at Independent Counsel in one of those Independent Counsel's office. They were supported by the Administrative Office of the U.S. Courts. They're a prosecutorial arm. Their oversight came from Congress. But all the the personnel, the paychecks, all that stuff came out of them. Buy space, equipment, all that stuff came out of the administrative office. So I think it's not a radical idea. It doesn't require a lot more money. It doesn't require any more money, really. So that's at the national level. At the local level, it's look at what the Prado Committee recommended these local boards and stuff. But you have a model now for panel attorneys for the administration of it in various federal defender offices that manage them. So I think that whether or not I know there's not universal acceptance that federal defender organizations should be managing the panel, but if you look at Mr. Kramer's testimony yesterday, or what goes on in the District of Oregon, in the Western District of, I guess it's just the District of Oregon, these other offices, you simply, take the judges out of the equation. They're no longer doing the voucher approval. And you would have a system in place. Doesn't involve, a lot more, more money and all sorts of other stuff. And you would have to have some more money maybe to add some services to other defender offices. Don't get me wrong about that. But in the scheme of things, in terms of offsets for what you'd get from from a congressional viewpoint, from what you'd get from offsets from the S&E account, sales and expenses account, it's not really a lot of money. And probably in this particular, from what I'm not familiar with the details of what the funding situation is in FY 2016, but if you were to look at what the resources, the FTE that's available in 2016, you might very well find you have enough FTE this year that you could actually add that staff to do that. So the thing that remains then is the appointment of federal public defenders, and I don't really have a particular view about that. If you want to leave it with courts of appeals to do those appointments, I guess you could leave it with courts of appeals to do those appointments. I would tend to think that if I were, I don't know how much feedback you've gotten on the development of these different models. But certainly you would want to, there's a variety of models out there in the states. You'd want to talk to a lot of different people to come up with a solution. But for some things, once you got these basic elements in place, you would then have with this, independent agency within the judicial branch. And let that group focus on the details of that. Maybe you'd have they'd be charged initially with a 5-year transition plan for developing another model for appointing federal public defenders or something, and you work out the details of it. So I don't think it is, I think that it's a doable solution, that not everything has to change all at once. You don't have to be spending a lot of money. You don't have to, it doesn't require it will be some rewrite of the statute, but it's more of a technical rewrite, so doesn't have the political risk that's associated with saying, well, Congress is going to take a whole review of the criminal justice system and be able to tinker that and the other things. So I think that that's some of the ideas I put forward.
I'd like to hear from Mr. Wolf and Mr. Burke as well, but let me throw out a couple of other ideas that Mr. Asen made me think about. You were talking about costs maybe not going up so much. I would wonder if costs should go up some because hourly rates, which for the attorneys may need to go up some. Mr. Burke's talked about training. I think there needs to be a lot more training in many different areas, but also for the use of experts and more use of experts, which would all, I think, potentially increase the cost of this. But Mr. Wolf?
Yeah, I don't disagree with anything that Steve said. I think that, that was basically the Prado committee approach was to have an independent agency within the judiciary. I think because that was viewed as the easiest leap, if you will, out from under the judicial conference and just stand on your own and have, the ability still to on a reimbursable basis or whatever, have the AO doing certain things as other judiciary agencies do. I think the ideal is, outside, is on your own. And I realize that's a bigger step. That requires, carrying more infrastructure, if you will, with you. My regret is that the first time around, we didn't get the first step done. But I'm certainly very sympathetic with David Patton's testimony yesterday about really breaking free. I think that anything would be better is really almost what I have to say in terms of the shift. It doesn't matter which one. I think you just have to move in order to eliminate some of the just inherent conflicts that are there. Yes, more resources for the things you mentioned. I mean, that could happen now if allowed. You don't have to change anything if you can advocate for those. But I think the structural concerns, form follows function, or what I think they say in architectural parlance. And as long as you have the budget committees and the executive committees and judicial conference, which is directed towards and not inappropriately, they're trying to run the judicial branch of the government, the defense function is different and it doesn't quite fit, and it can stand on its own at this point. So I would at least move it, as Steve suggested, thinking that's probably the more feasible likelihood, when you get into the realities of it.
Mr. Burt?
I'll be brief. I agree with Dick. I think ideally it's completely independent. I think it could work as an independent entity within the judiciary. The key, I think, is that whatever the governing body is should be made up of a majority of people who are knowledgeable about and experienced in federal criminal defense. I think in terms of the appointment of defenders, that body could do it, although I think it would be wise to have a mechanism that allowed them to get input from the district and circuits involved, because there are some, I think, important factors to be considered in that regard.
Let me just ask one more follow-up question, if I can, of Mr. Burke. Since training was sort of the area that you focused on, can you give us some insight about how you think training can be improved right now? We've got thousands of panel attorneys, and a lot of what we've heard is they don't know how to manage e-discovery. There's a whole lot of things they're not doing as far as when you look at service provider use, that it's extremely low. Can you give us a sense of how you think training should be improved in the future?
Yeah, training in this program is really is difficult because of the large number of panel attorneys, right? It's hard to reach all of them, and that's why I advocate for more resources, both in defender offices to allow them to do more training and more effective training, but also in defender services. The National Litigation Support Team has done, in my opinion, an amazing job in all aspects of their work, including training, but they're overwhelmed with the amount of work they have to do, so more resources are needed there. Because not only because of the voluminous discovery in some cases, but even in the routine cases, there's so much digital information and the technology changes so fast that it's difficult for people to keep up with it. And so more resources are needed to reach those people more regularly and training them on those issues and a number of other issues. The one other thing I would like to focus on, because we've talked a lot about some of the committees, but not as much about the AO, is that I think that this sort of singular focus of people in the AO on the judiciary, which is understandable given the body that it is really problematic. The example that I give in my written submission about procurement is, in some respects, has a lot to do with what frankly I consider to be poor management and leadership around the whole procurement issue that's existed for the whole 17 years that I was there, and is really probably beyond the scope of this committee. But I think it happens in part because of this singular focus on the judiciary, and frankly, in my experience, an unwillingness among a lot of people in the AO to listen to how this program is different and why you need different processes and different treatment. And I think over time, there's been more and more resistance in the AO to having those conversations. The example that Steve and Dick gave about the transfer of jurisdiction over the HR issues, I think is really illustrative. There's no way in my mind that the failure to consult with Defender Services before that was done was accidental or negligent. In my opinion, it was absolutely intentional. And in my opinion, it was incredibly irresponsible, lacked integrity and transparency. And those kinds of things happen too often. And I think are just clear signals and reasons for why this administration of the program doesn't work.
Thank you, Judge Carter.
Judge Prado.
Let me just thank all three of you for your years of service to Defender Services, to the Defender Services Committee, to community defenders, public defenders, panel attorneys. You've kept the system going, and thank you for all your hard work. Steve and I started about the same time. Hair was a different color then.
Here's what's
I probably had
Then
some.
you had more hair. And Dick, probably one of the best things that came out of the Prado Commission was that we discovered Dick Wolf, and he was able to join Defender Services, and he's really the guy who wrote the Prado report. So, Dick, thank you. I guess y'all were here yesterday. Y'all, that's the word we use back. You were here yesterday when the panel of public defenders was here, and I asked about, give me some horror stories, I guess is what I'm looking for. As a judge, you're looking for facts to back up recommendations of change. And what we hear is, everything's fine in my district. I've heard of other problems in other districts. And I guess I'm looking for those horror stories that we can then take as part of our report and say, look what's happening. This is horrible. We need to make the changes. But I'm thinking now that maybe it's a more subtle thing that is hard to articulate, and the fact that their horror stories might be more isolated, perhaps is enough to say there's a problem with the systemic way of doing things, that if it's happened there, it can happen here, and maybe change does need to be made, even though we don't have tons of stories, and that the influence is more subtle. Me writing a letter of recommendation to the public defender to hire my law clerk, telling the public defender how you might be unhappy with one of his lawyers, and that public defender has to come around for reappointment every 4 years, and the circuit asks the judges for their impression of that person. So there's some politics involved in that the public defender has to be nice to the judges and be a politician of sorts. And I'm just wondering if that is what we have, and is that enough to make the change? The fact that there aren't that many horror stories, or maybe you in the main office do know of a lot more stories that are difficult for the defenders themselves to speak about. If you could address that issue.
Well, let me say that when I heard you talk about that yesterday, I started making some notes in my little book.
You have a whole book?
Yeah, so I went through and I made a few notes about all the horror stories that I had. So if you can extend the hearing for another couple hours, I could.
Brief and a few mean different things to Steve than they do to me.
So I frankly, I think that, from the national perspective, from the national office, seeing the battles that we fought on the appropriation level and the policy level are the things that stand out to us, and reflecting on this after being away for a few years. And I do think that those, because they have such systemic impact on the ability to actually carry out through the service. There's stuff we haven't even talked about, battles over how much of a rate increase to ask for panel attorneys, which really, major impact on what happens. So I think that those are enough. At the same time, when there is an issue in a defender office, you do hear about it at the main office, because you have a relationship, because to some extent they think of you as a headquarters office, that you would have some history and some experience that can help them through certain situations. So you do get these calls over the years from different offices, sometimes from defenders, sometimes from judges seeing problems in defender offices. What do I do? And there is a tension with doing anything that involves, there is a certain pressure that comes from having a regular 4-year appointment. That's true for federal public defenders that doesn't really exist for community defender organizations, both in terms of trying to address problems in the office that you might see or that a judge might see in an office, or even a fellow defender might see in an office, because the amount of what's available as a remedy for a problem in a defender office, there's not like a subtle thing. There's appointment or not getting reappointed. That's sort of like the ultimate remedy. So you're sort of reluctant to do that. But I would just, to give you an idea, so over the years what I would get calls from defenders about would be judges who in a district regularly feed candidates to an office and say, I'd like you to hire these people. Judges who say in one district, more than one district, I want to see the candidates and interview them before you hire them, or at least want to see their names. We have, I think, offices where districts where I don't know that I want you providing representation in this class of cases because it's taking too long. It's not as efficient. I would say, to me, an example of interference in a systemic problem with interference in the operation of an office, I can think of one that's bigger, are the problems that have existed historically in the Fifth Circuit with defender offices not getting the staff, not even feeling that they were comfortable in putting in requests for attorney staff increases that they felt that they needed to the Circuit Court of Appeals because of the reactions that it would draw. People offices who felt reappointments would be, their job status would be impacted if they decided to put in a request to have a capital habeas office, an office devoted to doing capital work. Lawyers, offices that found compromises with who they felt compromised in their ability to make recommendations for appointment of counsel in capital cases, that certain recommendations would not be well received, and so I'm not going to do that. And I would even say that there are problems in any institutional defender office which needs to be confronted. I mean, whether or not you have federal judges or judges appointing you as a defender, if you're a defender and you're appearing every day in a court, you're part of a system, and there's always a tension between being a system player and being someone who's an advocate and an adversary. And you have to balance that. And there's all sorts of pressures, I think, that happen in defender offices all the time about that, which would go on under any system, and it's just part of the nature of the business. But they really, I think, get aggravated when you know that you're up for appointment every 4 years.
I'm going to mention actually a panel attorney thing that came to mind, which is for quite a while we talk about voucher cuts, but voucher delays was another significant issue that happened at times. It's one thing when the judge decides to cut you and you try your best, but that's that. But something else when a voucher sits on a desk somewhere, or, now it's in electronic, I gather, but somewhere in the courthouse is a voucher. And we would get calls about, I haven't been paid, I put it in. And of course, you're always wondering, well, is there truth to this? It's very, in our position, we couldn't know. All we could do is say, well, who have you talked to? Have you talked to the court? Have you talked to that? And on occasion, when there seemed to be a fair degree of credibility, we call the court, call the chief judge if we had to at times. That they never liked getting that call. They never wanted to talk to another judge about a voucher on their desk. And in the end, we devised a 90-day report as a means of at least fleshing out 90 days in chambers, that the circuits should send a report forward from each of the districts and the circuit when a voucher has been there for 90 days or more. And that helped. It was sort of interesting. When the judge's name went on a list, it actually seemed to help. There are always individual circumstances, but sometimes, I don't know if it was negligent or if it was punitive, that a panel attorney had to wait that long to get paid. And a lot of these attorneys need, as we know, are solos, and they need that payment to come through, whatever it's going to be. On the national level, another thing is sort of popped in my mind, and that is, for a long time, I don't know, this isn't a horror story, but it's just another sort of structural kind of interesting item. For a long time, the Judicial Conference policy has endorsed a federal defender becoming an ex officio member of the Sentencing Commission. The DOJ has a presence, judges are on it, private lawyers, but federal defenders who do the bulk of the work they're given a statutory right to comment on guidelines and things of that sort. So conference policy endorses that. And there was a time on one of the criminal crime bills that was going through that it looked like they might be able to attach a rider or whatever and get through. There was a little bit of optimism, maybe this is the time. And we started a process in the office and with the Defender Services Advisory Group of, okay, well, how functionally, how will we do this? How would this be done? And of course, the defenders basically said, well, we'll pick a person to be on the commission, or we'll put the name forward. And I started this process of contacting others in the AO about that being done. And it was resisted in many quarters that defenders would just name some, who they think should be the nominee or whatever, the appointee. And there's a tradition that I think is within the judiciary about, whether it's slots on judicial conference committees or various things, that oftentimes two names go up at least to the director, or he takes them to the chief justice, but there's always sort of a choice there or whatever. To me, and we seem to get it through eventually, all these different layers, and it took a long time, but it got to the director's office, and it never came back. It never came. We could never sort of free that up. So that's just a small issue, but it sort of strikes me as symptomatic of control. There's always just that little tweak of having we want two names, or we want to pick. Well, the same things happen with congressional detailees. Congress has asked for defenders to help on the Hill. And they sometimes ask for specific individuals. Well, the administrative office, legislative affairs, they hate that. They can't stand, this is not something that Congress should be picking, we should be deciding. And again, they want a couple of names. They never want, to just forward one name, or even when it's a rather important member of Congress, they don't just say, all right, we will, or there's no particular reason perhaps that they might not want to send somebody. But there's the broader concern too of the size of that detailee operation, if you will, because the courts may want detailees. The courts have their own concerns, and that's why it just doesn't it doesn't fit. It should be separate, and the court wouldn't have to worry about that. The judiciary wouldn't have to have that worry.
Okay. I'm assuming had there been a separate committee like the Sentencing Commission or FJC, sequestration hit them just like everybody else. Had there been a Defender Commission, would sequestration have been handled differently and not had the impact that it had been under the courts?
I mean, I think Steve was describing, I think it probably would be, because I don't think they would have started with a cut of a rate. They would have, tried to minimize the impact up front. And the other thing is that if there's a separate agency, we'd have congressional relations. I mean, we would have direct contact with the members of the Appropriations Subcommittee and be able to have, they know impacts better. I mean, eventually it happened, but it was after damage had been done. And I think that had we been in a separate agency and been able to communicate more directly and had a consistent congressional relationship, there would have been a better appreciation of what that impact could be, and it could have been avoided.
But I think it's,
Go ahead, Steve.
I think it's important to Dick's point
Microphone, Mr. Reese.
I think it's important that, to Dick's point, that, when you go back and say what if, what might have been, you have to put it in a context. Had we had a separate authority, separate ongoing relationship with Congress in developing a response to sequestration, there would have been a dialogue directly about our program and what the problems we were facing. We would have worked out some solution. But I think the short answer is yes, based upon the fact that the Committee on Defender Services, which itself, my recollection, was understood the competing needs and its role within the Judicial Conference, but it itself, even taking into account judiciary-wide concerns, came up with a different approach that was derived from discussions with the advisory group and input from defenders and panel attorneys. So I think, at least to that extent, one can say it would have been a different approach and would have had a different outcome.
And Judge, if you don't mind, I'd like to go back to your first question and address it with regard to the panel. I think that this question of having sort of a critical mass of horror stories is a problem, and probably was for the committee that carried your name. But I guess I have a couple of thoughts about it. The first one is, I just think it's a conflict for judges who have a financial interest in seeing their mission and their interests funded, their salaries, their buildings, their staff, to be making decisions about pay issues and resource issues for CJ panel attorneys. And that just, to me, is sufficient for removing that function from them. But you've heard testimony from a number of panel attorneys that I think provide some really good examples of how that problem plays out. It's a limited number, but I can tell you from talking to panel attorneys all around the country, there are more examples. They often aren't documented because the lawyers fear a certain retribution, that they won't get cases or won't be reassigned to the panel.
I'm shocked.
But I
shocked
think
that goes on.
yeah, but I think that if there are 50 or 60 or 80 in a year, that's too many.
How do you see this new committee, whatever we call it, how do you see the makeup of it? Right now, it's Defender Services is all judges. Would there still be judges on the committee? Who would appoint the new committee? And maybe that's up for us to do, but do you have any idea of what you envision this committee looking like?
Well, I mean, I guess I have two thoughts about it. I don't have detailed ideas about exactly who would appoint it, but as I said earlier, I think a majority of them should be people knowledgeable about and experienced in federal criminal defense. I think that it would make some sense to have judges on the committee. I think there's value and input that you can get from them about the operation of the defense system and the impact that it can have on the court, that it's important for people to consider. But they shouldn't be in a position where they have a majority and can control the outcomes.
I think I'm not as inclined to have judges on the committee. I mean, as I said, the defense function is really a separate function. And what's happened is we're used to it this way, right? I mean, it got put in the judiciary. We've gotten used to the fact that the judiciary oversees the program. But Congress itself, when they set up defender offices, said, we're going to need strong, independent leadership, outside judicial control. And I mean, absolutely, the defense function, I think they would want consultation with the federal judiciary. I would assume there'd be judicial relations. There'd be relations with the Department of Justice. I think there are a lot of avenues that if the defender function was separated, of cooperation that might take place between the Justice Department and the defense function, that some of which happens now, but it's the exception rather than the rule. I mean, the e-discovery is an example of a collaboration that was for the good of everyone. There are other circumstances, I think, where those collaborations might take place, but they're harder to do in the current arrangement. I mean, I think there is a whole potential that would be freed up. And I think the judiciary is going to be a very important constituency for the defense function always. But I don't know that a judge needs to be on the board, essentially running, the program. And in a sense, all that confidentiality concern, of what can we say and what can't we say and what might go, I wouldn't want to put a judge in that position.
I think Dick makes a good point, so I retract my. I think that there could be cooperation with the judiciary and DOJ outside of this entity, but especially the confidentiality concerns are a critical one.
Steve, short answer, because the chair is
Yeah,
yours.
we're running over.
Okay, well, I don't have a strong view. I think that I looked at this somewhat when we staffed that study that Judge Gleason was chairing a number of years ago and brought in models from around the country, and I think that that's what I would look to. I think it's a complex question. I think it's a question of how much time your committee has to draw on all the different views to give it full consideration. I think it's enough for your committee to say that there are shortcomings in the current system, that independent governing public defense mission governing board should be established of some sort, and perhaps pursue with a lot of different input what that should look like. And the other thing I think is that when you come up with these proposals, I mean, I think that there's a lot of complexity, but the issue, for example, whether or not it should be within the judicial branch of government has an implication for where the appropriation is, right? If all these commissions and the FJC and the Sentencing, they're all part of the judiciary's appropriations, which means that we go to the same appropriations committee as the judiciary, which means maybe there's some inherent conflict in there, maybe not a good idea to do that.
Can I follow up with something? There has been a suggestion that it be placed somehow, because we hear about parity with the DOJ, and that there's no way to get those numbers or to really for anyone to compare numbers between the defense function and the Department of Justice. But if somehow the defense budget was in the same committee as the Department of Justice budget, that the people that make those decisions would be able to compare apples with apples and see, what's going on in DOJ versus what's going on. Any thoughts about that,
Well,
having worked in this?
the judiciary used to be in Commerce, Justice, State, Judiciary, and related agencies, and we used to be in the same general appropriation with Department of Justice. And, you know, at the time, you know, we would try to make those comparisons and get the staff to work on it. You know, the fact that we didn't have great success at doing that doesn't mean it won't happen in the future. That's why I think I would get
But
into
that's when you were, when it was still in the judiciary.
which
I'm
is still in
saying is
judiciary.
if
So if it's on the
somehow-
outside, I think you might have a greater capacity to doing that, but I don't have the expertise in that. That's the type of thing I would, in making this decision, I would look to get some input from congressional staff, appropriations staff in particular, because a lot of staff on the Hill are not familiar with appropriations processes, to sort of get those ideas and insights. And that question might drive your decision as to whether or not it's within the judicial branch or not. I just don't know. I'm just raising it as issues for you to look at.
Thank you. Anybody in the back? Anybody?
Just a quick question for Mr. Azen, and if we are to certainly remove the authority from the U.S. Judicial Conference, you had talked about the Office of Independent Counsel. What type of model is that as opposed to like FJ? I'm familiar with Sentencing Commission and FJC that may be within the judiciary, but just briefly.
Well, I'd have to be brief because I'd ask, you'd have to really not rely on me for that.
Okay.
But essentially, you know, if you look back at the Independent Counsel Act, it's set up under the direct control of Congress. There is some administrative support that they get and services they got from the Department of Justice, but it was insulated within there.
Yeah.
So you'd have to actually look at how
And
that is done.
you know, frankly, that interests me somewhat, but we'll.
Yeah, I mean,
we'll
it
take
is
a
an
look.
interesting thing. I
Okay.
think I invite you to
Okay.
explore that.
Thank you. That's
Nobody? On behalf of the entire committee, thank you so much. Really, it has been tremendously helpful. The historical perspective is exactly that. It's tremendously helpful to get that depth. And so we appreciate, as Judge Prado said, your years of service and your willingness to come and speak with us frankly. As I've said before, if this has spurred any thoughts, I think Judge Prado and Dr. Rucker mentioned that if you have any ideas about structure, if you have any further comments you want to make, please feel free to submit those to us. We are happy to receive them. But on behalf of the entire committee, we want to thank you.